Hi, thanks for stopping by to another dose of bite-sized bits of knowledge where we give you a meaningful amount of information in a short amount of time. Today we're going to talk about advanced care directives and why they're important, and from a cost-benefit perspective, why they're no-brainers. So, let's dig in. Big picture, what we're talking about here are things that matter during life and expire on death. Very important. Expire on death. We get a lot of calls about that. Expire on death. Power of attorney, healthcare surrogate, living will. Power of attorney, healthcare surrogate, living will. Power of attorney is a document that empowers your agent. It used to be called an attorney in fact, but now it's called an agent, to act on your behalf with respect to financial matters, administrative matters, tax, business, banking, credit, lending, legal, taxes. I think it said it's twice as bad. Comcast, it's a joke. Everything basically that you do on a day-to-day basis as a person with, as a citizen with rights, they can do for you with a broad power of attorney. They can be as broad or as narrow as you want them to be. It's just a document. In estate planning context, it's typically, a trusted person you're doing this with, and you trust them, so it's very broad. But suffice it to say that the advanced care directives, the power of attorney, in the words of a now retired judge in Broward County, is weapons of mass destruction. Because in the wrong hands, it can do some serious harm. I will mention in that respect that the agent has a fiduciary duty to administer your affairs for your benefit as the principal. Fiduciary duty, which I think I've mentioned before in a prior video, is a person or is a duty that's an elevated standard of care above negligence. It means that you have the obligation, you have a duty to put the principal's interest ahead of your own interest. So if you start engaging in self-dealing or conflicts of interests, you generally will be personally liable for those damages. So it's not negligence, which is a reasonable, prudent person standard. This is a elevated standard of care. So power of attorney, dangerous in the wrong hands. Really got to think it through. That's part of our process, is to really understand, who you're appointing and are they qualified, are they trustworthy, are they diligent, and so forth. Similar to a power of attorney is a medical power of attorney or healthcare surrogate. It is a document that empowers your healthcare surrogate to make medical decisions on your behalf in the event that you cannot make them yourself. So obviously there's a lot of nuances with these documents, but I'm just trying to keep it simple. So the medical power of attorney, your healthcare surrogate, your healthcare proxy, whatever you want to call it, this person is appointed to make your decisions if you can't do it. If you're unconscious and you need a procedure done and you're in the hospital and the doctor's like, what do we do? They're going to talk to this person. This person is going to have the obligation, again, a fiduciary, to figure out what are the options, what are the risks, and pick a treatment and pull a trigger. You probably, I would imagine, want to choose that person as opposed to the court choosing it for you, which would be done via a guardianship. So these are important documents. The last one is the living will. The living will is a document that I've seen in many instances appoint somebody, and our firm, we do not appoint anybody. It's just a document that expresses your wishes, whether it be artificially on life support, in the event that you're in a persistent vegetative state, or you have a terminal illness or end-stage condition. And two doctors say that there's no reasonable likelihood of recovery. So it's like you're in these terrible states, but also there's multiple doctors that are saying that there's really no likelihood of recovery. So you're not going in because you stubbed your toe and they're gonna kill you. It's just, do you want to have that extra, do you want to have the extra support to keep you alive longer to see if you're going to come out of it? And I would say most people say no. Most people say no. They don't want to put that burden on their family. And that's what it's all about. It's a burden on the family, and the family's left to wonder, what did they want? I don't want to struggle with the decision of being wrong about what they would have wanted. I want to do what they would have wanted. So this is telling what you want, and it's alleviating a big financial and emotional burden. I'll say 2 more things before I wrap. Number 1, power of attorney is effective immediately now. There's no longer a springing power of attorney. It's effective immediately, so you got to be really careful. We have some creative solutions for maybe limiting the risk of someone who has the power immediately. And then similarly, the healthcare surrogate actually now has a part to it where you can make it effective immediately, like the power of attorney. But the principal is still in charge. You're still in control. They have the right to access information. It's otherwise protected under HIPAA. They have the right to participate, but your voice will control as long as you have one. So these are really important. They're not the most complex, but they all do require some thinking. Don't knee-jerk into doing them yourself. And if you ever want any help, give us a call. Thank you for stopping by, and stay tuned for more.
Hey Mo,